Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled, Attorneys Motion to Dismiss Appeal Denied. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, I would like for you all to hit that like button. And also, if you're new to my channel, hit that subscribe button. And also, hit that notification bell so you all can be notified as I'm dropping these power videos. So without further ado, let's get to it. Okay, so now, as you all can see on the screen, this document was in fact filed in the Supreme Court of the State of New York, Appellate Division, 2nd Department. Below that, it states what? In the matter of a proceeding under Article 5 of the Family Court Act, my ox child's mom name I crossed out, so we're going to simply call her Mrs. Aura, and the court has her as anonymous. Also, she's the petitioner slash respondent. Why is she the petitioner slash respondent? Because in the trial court, which is the family court, she was the petitioner. But in the appeals court, she's known as the respondent. Same as below, where it states versus, she versus my ox, we're going to call him Nate A, who's also known as anonymous, and he's the respondent slash appellant for the same reason stated above, because in the trial court, which is the family court, my ox is the respondent to his child's mom, who's the petitioner. But in the court of appeals, he's the appellant, and then she's the respondent, okay? So now, again, the title of the document is Affirmation in Support of Notice of Motion to Dismiss Appeal. Also, the case number I crossed out. But let's pick this up at the top. The attorney name I crossed out, but we're going to simply call the attorney Esquire, and it reads, an attorney admitted to practice law in the state of New York affirms under penalty of perjury, 1. I am court-appointed attorney for the respondent, and I respectfully submit this motion for an order dismissing the appeal. So now, as you all can see by reading the first sentence, let's get straight to the point. She's the court-appointed attorney for the respondent, and she simply moved the court to dismiss my ox appeal. But let's continue. It states, appellant appeals the order of the Honorable, guys, I cannot pronounce that judge's name, so I'm just going to go right past it. Then it states of the Queens County Family Court, entered on June 25th, 2024. Appended as Exhibit A, Notice of Appeal and Orders. Then it states, the order is appended as C. Appellant did not attach the order to his Notice of Appeal. Let's read number 2. In furtherance of the arguments made in respondent's brief, appended as Exhibit B brief, respondent moves this court for an order dismissing the appeal for lack of subject matter jurisdiction. So now as you all can see, now the respondent, who is his child's mom's attorney, she moved the appeals court to dismiss my ox appeal for lack of subject matter jurisdiction. And she's going to further explain why she believed the case should be, or the appeal should be dismissed. Now let's read it. It states, this court will respectfully take judicial notice of appellant's proof of service of the notice of appeal. Appellant has sworn under oath that he himself served the notice of appeal, which is true, guys. Ma'ak, who is the appellant, he did file his own notice of appeal, which he could do according to what? According to the appellant rules of procedures, okay? But let's continue on. It states, service by a party is akin to non-service at all. It is fatal to this court's subject matter jurisdiction, CPLR 2103AA. So she's simply using CPLR 2103AA to explain why she believed that because he filed his notice of appeal himself, the court loses jurisdiction and should dismiss his appeal. Then it states, who can serve except otherwise. Now let's go to the next page. Okay, so now we're on page 2, and it reads, prescribed by law or order of court, papers may be served by any person, not a party of the age of 18 years or over. So basically, she's stating, according to CPLR 2103AA, that because Ma'ak was a party to the case, that he cannot serve the notice of appeal, which is simply not true. CPLR 2103AA is for the family court. Okay, so if he was serving documents for the family court, then someone who's not a party to the case, who's 18 years or over, can and will and must send or serve documents to the opposing party. But let's continue. 3. While the court has the discretion to correct an improperly filed notice of appeal, case law she using to support that, it states, no such application has been made, and even if made, there is no justifiable to grant the relief. Another case law she's using to support that. But what she's failing to understand is that because he followed everything properly, he doesn't need an application in order for the court to grant his notice of appeal. Why? Because we did everything according to the rules and civil procedures, or should I say appellate procedures. But let's continue on. 4. The appeal should be dismissed as judicially defective with the case law she's using to support that. Then it states number 5. No prior application for this release has been made. Then it states, wherefore, your affirmant respectfully asks this court to dismiss the appeal with prejudice, dated February the 19th, 2025, signed by the Esquire guys. So this is in fact again, we just went over the affirmation in support of the motion. So now let's go over the motion so you all can see that she in fact did really file a motion to try to dismiss my ox appeal. So without further ado, let's go there. Okay, so now as you all can see, we're at the notice of motion to dismiss appeal. The header and the parties and everything else is still the same. Let's continue on. Let's pick this up at the very top. And it reads, please take notice that upon the annexed affirmation of the Esquire, we know the Esquire again is who? The Esquire is his child's mom's court appointed attorney. But let's continue. It's stated, dated the 19th day of February 2025. So the same date that we just read on the affirmation that was done by the Esquire. But let's continue. And upon the notice of appeal appended hereto, and upon all of the papers and proceedings heretofore had herein, the undersigned will move this court at a motion part thereof to be held at the courthouse located at 45 Monroe Place, Brooklyn, New York, the 10th day of March 2025 at 9:30 o'clock in the forenoon of that day, or as soon thereafter as counsel can be heard for an order. A. Dismissing the appeal upon the grounds that the service of notice of appeal is judicially defective, and B. Such other relief as may appear to be just and proper. Dated Queens, New York, February 19th, 2025. Esquire information again now crossed out so you all can see that this is in fact the actual motion to dismiss that she filed to the court and the affirmation we just read in support of this motion to dismiss. So now that she's filed this, we filed our rebuttals to this. Now let's see what the court order or the court ruling on this motion to dismiss. Let's go there. Okay, so now as you all can see on the screen, this is in fact the decision and order on motion, and we're still in where? We're still in the Supreme Court of the State of New York, Appellate Division, Second Judicial Department. At the very top are the 4 justices that's ruling over the case. Again, the case numbers and everything else are crossed out, and all the parties' names are crossed out. And it reads, an appeal from an order of the Family Court, Queens County, dated June 25th, 2024, motion by the respondent to dismiss the appeal on the grounds that the notice of appeal was not properly served upon the respondent, upon the papers filed in support of the motion and the papers filed in opposition thereto. It is ordered that the motion is what, guys? Highlighted in red, denied. And those are the 4 justices that ruled on the matter. So again, guys, as you all can see, these attorneys don't have a clue what they're doing. They just throw anything out there. And if you don't understand or know or probably know how to defend yourself in these courts, then the chief justices and all the lower courts will go with them. But if you know how to properly respond and stand on your square and do things correctly, then you will receive remedy, guys. Like I tell you all, this is not an easy fight. But it's a fight worth fighting, especially when you all putting in that work and getting the results that you all desire, okay? But that's all I'm going to do for today. If you all need my help, hit me up at my email at y'allismagnified@gmail.com. Let's get this right wisdom, this right knowledge, and this right understanding. With that being said, you all be blessed, and I say shalom.